Welcome back. At this point, we've reached a particular interesting juncture in our guided tour of the written Constitution. We've talked about the preamble, how the Constitution was ordained and established by the people. We've talked about Articles 1, 2, and 3, vesting powers in a Congress, in a president, and a judiciary, the legislative, executive, and judicial powers, respectively. We've talked about Article 4, which outlines the significance of horizontal federalism, the relationship of states between amongst themselves and vis-a-vis the federal government, and of territories. We've talked about Articles 5, 6, and 7, which showcase the idea of the supremacy of the Constitution, how amendments to the Constitution require specially broad democratic consensus in Article 5, how the Constitution is the supreme law of the land, notwithstanding anything that a state might say to the contrary, or Congress, or the President, or federal courts for that matter, in Article 6. And we've talked about how Article 7 completes the project, mirroring and echoing the preamble, kind of a bookend to the preamble, specifying the particular ways in which we, the people of the United States, via special conventions, did in fact ordain and establish the Constitution, and in ways that we did so that actually originally did not involve all 13 states saying, yes, we do, but originally only 11. 9 would have sufficed for the Constitution to go into effect among those states so ratifying. So that's where we are. We've come to the end of the original Constitution, and now we're going to start talking about the amendments. And we reached, as I said, a particularly interesting juncture because it turns out that the amendments are tacked on to the end of the document. That didn't have to have been the case. In many state constitutions, amendments are basically woven into the earlier document. In effect, the earlier document is word processed, and you get version 2.0 and 3.0, and it looks just seamless. But that's not how our Constitution, the federal Constitution that is, has in fact been amended. The textual amendments have just been added to the end chronologically as so many postscripts, PSs and PPSs and PPSs, like a careless written letter, a critic actually once said. But this is a reminder of one hugely important truth about the Constitution, that our Constitution is an intergenerational project. It's not merely the achievement of a group of founders, but actually a group of founders and amenders. Later generations of Americans are going to add these texts to the Constitution, and we're going to be able to see them, the contributions of these later generations, with distinctive clarity, because it turns out the amendments were added sequentially and chronologically. So we've been talking a lot about the founding era in the lectures thus far. The lectures going forward are going to carry us forward in time through a Bill of Rights that actually arose in the founding era and a couple of other early amendments, and then a later spurt of amendments after the Civil War, another burst of amendments at the beginning of the 20th century, a final burst of amendments at in the middle and end of the 20th century. So the juncture that we've reached is one in which we're beginning to close the book on the original Constitution and open the book on the world of constitutional amendment. And this seems a good point to remind us of just the larger constitutional project before I start to talk about the early amendments, which we call the Bill of Rights. That phrase, in fact, is not in the Constitution, and I'll tell you a little bit about the origins of this phrase, the Bill of Rights. But before I talk about Amendments 1 to 10, the first set of amendments, which in the Constitution, in the written Constitution, start right after Article 7. Before I do that, let me just stop and pause and say a word or two about this extraordinary intergenerational constitutional project and its world historical achievements and significance. What have the American people over the course of our history actually given to the world? And I think we've given to the world some extraordinary things, and these things are part of a larger intergenerational constitutional project. The project, in some sense, begins even before the Constitution with the achievement of independence, a Declaration of Independence, which, let's remember, actually gave reasons for breaking the ties that had bound the colonists to the mother country. So it was important that Americans actually put down on paper their justification. They submitted facts to a candid world about why they felt impelled to separate from King George because of all the abuses that had been perpetrated and how their petitions and remonstrances had fallen on deaf ears. Our revolution was organized around ideas and principles. It stood for something. We hold these truths to be self-evident, and certain principles were put forward. Now, those principles weren't always understood expansively. All men are created equal. Those words were penned by a slaveholder who doesn't free his slaves at his death, Thomas Jefferson. Yet those words would grow over time intergenerationally. Lincoln's generation would give those words a deeper and richer meaning than the founders did, and those words will continue to grow and expand over the course of American constitutional history, and that's what we're going to be talking about, how the words from early eras do get built upon by later generations. But the American Revolution was a successful military revolution, but it was organized around ideas. It does not, even though many people in America are opposed to independence, this successful colonial revolution does not end in a bloodbath in the streets with people slitting each other's throats in civil society the way the French Revolution does. It doesn't end with a kind of despotism that one sees with later Russian Revolution, Chinese Revolution. As revolutions go, military revolutions, it's a successful colonial revolution. It's rather admirable. It's not completely bloodless. It's not velvet. There had to be a war. It's not quite like the Czech Velvet Revolution in the late 20th century, but it's pretty impressive. Folks who oppose the revolution are not guillotined. They're kind of voted off the island. They're politically ostracized, but it's still pretty impressive. There's a military leader who emerges, George Washington, and he gives up military power. He surrenders it. That's not true in most revolutions. These military figures actually hold on to power forever. The Fidel Castros and Ho Chi Minhs and Mao Zedongs and Lenin. So in the history of the world, these Napoleon, the American Revolution is pretty impressive, it seems to me. It's about ideas, and the dissenters are ostracized to some extent, the loyalists, but not guillotined, as will happen in the French Revolution. And this leads to a constitution. So that's the first big kind of American project, modeling for the world a successful colonial revolution that doesn't spiral out of control. And it leads to, and a revolution is a kind of negation, saying no to something. We cast off the English yoke. We reject that, but then we have to build something presumably better. To lay the foundations of a new government that will protect unalienable rights. That's the project, says the Declaration of Independence. It's the right and the duty of a people when they confront a tyrant to throw off the tyranny and erect new governments, to alter and abolish their system to make it better. And the first iteration, the first round of great constitutional reform, very exciting constitutional reform in America, is at the state level. A bunch of state constitutions emerging in 1776 and thereafter, and trying out different ideas. And there's some experimentation, and some state projects work and others don't. The Massachusetts Constitution, for example, in 1780, is put before the electorate, and they say yes, modeling what will become a federal practice in 1788 of getting the entire continent to vote on a constitution. So the first round is state constitutions, and a lot of them are written, and they have bills of rights or declarations of rights, and they map the powers of government, and they try to delimit the powers of government. And some of these state constitutions work fairly well, others less so. And there's a period of democratic experimentation, and then the U.S. Constitution comes along and tries to build on the best practices of the state constitutions. Massachusetts put its constitution to a vote. That was a good idea. We'll do the same. Most states have 3 branches of government. We'll follow that model. Most states have bicameral legislatures, not Pennsylvania. We'll follow that model. Pennsylvania pays its lawmakers. That's a good idea. We'll do the same thing. Pennsylvania and New York provide for a census so that when people move around, the size of and shape of the legislature changes. We should do the same thing. Massachusetts has a strong executive branch. We think that's a good idea. We'll follow its example on that, and New York too, and so on. So the framers are borrowing some of the best practices that have emerged from the state constitutions, and that's the next great step in this epic constitutional project, giving the world an example of a continental democracy voted on up and down a continent by people who had a chance to participate. I argued in the early lectures that was the hinge of human history. It was extraordinary. And that conversation that the Americans had up and down the continent is going to lead to future reforms like a Bill of Rights, which we're going to talk about very soon. So out of that conversation come additional good ideas and new ideas when you get people talking to each other up and down the continent. But we're not done. This intergenerational project is only getting started. It needs to secure this new fledgling nation, its security and geostrategic independence, and this is going to ultimately mean that Louisiana is going to be, that the territory is going to be acquired from France. You kick kind of the old ancien regime, the old monarchies, out of the new world. The most important constitutional decisions in America haven't always been court cases. They've involved presidential actions, like Jefferson acquiring Louisiana. Marbury versus Madison is the same year, 1803. But I don't think it's the most important constitutional decision of all time. It's not even the most important constitutional decision of 1803. It's the Louisiana Purchase. Remember, Marbury versus Madison says courts can strike down acts of Congress that they think are unconstitutional, but courts don't do that very often. That's the only time John Marshall does it. That's the only time actually judicial review actually occurs at the Supreme Court level of vis-a-vis an act of Congress for the entire antebellum period, for the entire period before 1850. And so judicial review is going to become important later on, but Marbury in context isn't so important. It's the Louisiana Purchase, which doubles the size of the United States, and now here's the next big constitutional project, taking all this virgin territory and turning these territories into republican states that will be admitted on equal footing, on equal terms with the old states. We're not going to colonize over these new lands. And that's an extraordinary project, sort of an anti-colonial project. We're going to take an entire continent eventually and basically working our way from the eastern seaboard. We're going to work our way all the way to the Pacific Ocean, take these territories, and eventually turn them into states. It's a great, epic project. It can be criticized. There are losers in this project. The Native Americans are the big losers in this project of manifest destiny and the Monroe Doctrine. But we create, at the end of this, and it's an epic constitutional achievement, and it takes time to do, we create a continental republic of equal states, where no state gets to lord over other states. Lincoln's project, you will recall, is unifying the nation not just north and south, resisting unilateral secession, but east and west through a transcontinental railroad. It's an epic constitutional project. It will succeed in creating a great superpower. The next great constitutional project, ending slavery. Remember, the framers compromised with slavery. They created a house divided. They were lucky. We were just lucky that this Western territory wasn't all slavery. It could have been. Nothing in the Constitution prevented that. Fortunately, the Indians were defeated in the north in Ohio before they were early on, and so lots of settlement occurred actually in the northwest before it occurred in the southwest, and the path of expansion didn't result in all the territories being slave territory, as might have happened. And then, boy, American history would be very different, but it didn't quite happen that way, and but it was still a house divided. It wasn't all slavery, but it wasn't all free, this western land, and eventually a war will come. We're going to talk about that a lot in later lectures, because slavery in the territories was just sort of left an open question. But the next great constitutional project, and again, remember, we're kind of beginning to carry the story forward in time, so this is a preview of coming attractions. The next great constitutional project will be ending slavery, Lincoln's constitutional project, affirming the equal rights of black Americans, their civil rights, and eventually their political rights, their equal voting rights, preserving liberty not just against the central government, but against the states. That's going to be a great Reconstruction project, and all these promises are made. They're not fully lived out until really later in the 20th and early 21st century, but it's an amazing constitutional example for the world. Imagine how different the world would look if America hadn't ended slavery. And then Hitler comes along with his principles of Aryan supremacy, and he reintroduces slavery onto the continent of Europe. And that might have succeeded had America still been a slaveholding society, or a society committed to the supremacy of one race over another. But America wasn't that by the time Hitler comes along. America is an anti-slavery society by the time Hitler comes along, committed to a principle of racial equality. It's not living it out fully yet, but it's committed to that principle. That idea that all men are created equal has now been, in effect, written into the Constitution, and not just the Declaration of Independence. Now it's part of the supreme law of the land, and it means something far more robust. And we're still not done, the American constitutional project. Because of America's military might and its principles, begun in the Declaration of Independence and built upon, America in the 20th century will defeat Nazism and Italian fascism and Japanese military aggressive imperialistic authoritarianism, and a Cold War will emerge after that, and our vision will basically thwart Soviet communism, and in the process, we will begin to rebuild the world in our image, a Marshall Plan rebuilding Western Europe, taking Japan and rebuilding it as a more tolerant, democratic, open society, and Germany too. It's an extraordinary constitutional project made powerful by the geostrategic might of the United States, by Lincoln's vision to unify the nation north and south and east and west, and stand fast on the idea that slavery is wrong and must end, and ultimately the deep principle is that all men are created equal. But think about how many societies in the history of the world have ever sort of, I think, done as much as the United States has, from the Declaration to the present moment. And let me say one other thing about the present moment. In our lifetime, we are genuinely living out this idea of a multicultural, multi-religious, multilingual society where everyone really is created equal. We're beginning to really not just redeem the promise of these later constitutional amendments that promise equality. Barack Obama is President of the United States, pretty striking. People of all faiths are eligible to run for office, even the highest office in the land, and people of no faith. It's open to all, low-born people, high-born people. Great cities like New York and San Francisco are places really where north meets south and east meets west, where people from all the world, from Asia, from Africa, from Northern Europe, from Southern Europe, are coming together in this new world and modeling, I think, for the rest of the world an example of a genuinely democratic, pluralistic, multicultural society. It began with the Declaration of Independence. It traveled through the Constitution and the War of 1812, sort of re-securing independence, and the Louisiana Purchase, and the democratization of and republicanization of the West, the ending of slavery, the rebuilding of the house divided, the extraordinary world achievements of America in World War II, and the Cold War, basically vindicating our fundamental values against those of intolerance and repression in the Ancien regime, and that story continues. So to conclude this lecture, and then we'll start talking about the amendments. The amendments are a reminder that our constitutional project does not end in 1789. It's an intergenerational project. The project actually is ongoing today. The Big Bang, if you will, of the founding, which created these amazing reverberations, a certain democratic momentum for America and the world, we're still feeling all of that. And what we're going to do for the rest of this segment of the course, as we work through the rest of the Constitution after Article 7, is carry our story forward in time, through a Bill of Rights, through the Jeffersonian era, and then Lincoln's generation, and then the progressive era of the early 20th century, the 1960s amendments, the Second Reconstruction, and up to the present. So stay tuned. Welcome back. Let's talk about the first 10 amendments to the Constitution. We call them the Bill of Rights, even though that phrase doesn't appear in the Constitution itself, and indeed wasn't always used and regularly used to describe these amendments, in at least in Supreme Court cases, until much later in American history. I'll tell you the story about how that phrase comes to become much more common in later lectures, basically, but just to foreshadow, the framers of the 14th Amendment after the Civil War like to refer to these amendments as the Bill of Rights, and that caught fire. But these amendments were proposed in the first Congress in 1789 and ratified shortly thereafter, 1791. And today, they're absolutely central and iconic. Not so much, actually, in the early period. They don't mean that much on the ground for much of early American history, but they come to become absolutely huge. The big themes of these early amendments are federalism, or localism, if you will, and populism. These amendments, to some extent, are a reflection of a kind of anti-federalist critique of the original Constitution. Remember, the Anti-Federalists were worried that the Constitution created too powerful a central government without enough checks on it. They were nervous, and they also wanted to beef up state and local power to some extent as a counterweight against federal authority. Remember, the American Constitution follows the American Revolution, and the Revolution was a revolution against an imperial center, a revolution led by an alliance of local governments, colonial assemblies, and local juries, local militias. And the Constitution was proposing this vast, powerful federal government, continental government, the likes of which supposedly Democratic or Republican central government, the likes of which really hadn't been seen in world history, and anti-federalists were worried, and they said that during the ratification convention, and the Bill of Rights that emerges to some degree is a reflection of their concerns. It begins with the words, "Congress shall make no law of a certain sort," that is, laws restricting free expression and religious freedom. So it begins, "Congress shall make no law of a certain sort," ends with a 10th Amendment affirming basically states' rights and the idea of limited federal power. All of these amendments limit the federal government and only the federal government because the Anti-Federalists were nervous about the federal government. Now, James Madison, who proposes these amendments in the first Congress, he actually thinks that states need to be restricted too. He proposes an amendment that no state should abridge free speech or free press or religious freedom, but actually Congress doesn't go along with that. The Senate basically nixes that idea. The Senate is, remember, controlled by people elected by state legislatures. It's a bastion of states' rights to some extent. And so Madison thinks we need a Bill of Rights against the local governments as well as against the center. And I think ultimately history has proved Madison right on that, but we don't really get that second Bill of Rights, that Bill of Rights against the state governments and local governments until after the Civil War. So our Bill of Rights begins, Congress shall make no law, and only after the Civil War do we get the Madisonian supplement, no state shall abridge certain fundamental rights. The localism idea, you see it in the First Amendment. Congress can't pass laws. Congress can't establish a national church, but actually states can have established churches, and some did. And not only can Congress not establish a national church, Congress can't disestablish state churches. That would be a congressional law respecting on the topic of, in reference to an establishment of religion, and Congress simply has to butt out of that, leave it up to states, local option. It's a states' rights provision to some extent. The very words, Congress shall make no law, is really a recognition that there's no enumerated power over certain domains. Congress just has to butt out of certain areas. The First Amendment has a federalism component. The Second Amendment is about protecting, to some extent, state militias against a central standing army. There's anxiety about an army, and suppose it becomes a military dictatorship. Well, local militias could resist if there's a national military coup of sorts, just as local militias had arrayed themselves against the King's Men in places like Lexington and Concord and Bunkers Hill. So that's a localist amendment. The militia idea is a local idea. I was getting ahead of myself. So is the jury idea, which you see in a bunch of other amendments. Juries are local bodies resisting to some extent or counterbalancing national judges. The 10th Amendment is another localist idea, enumerated federal powers and other things reserved to the states or to the people. The 9th Amendment is a recognition that, again, at least in part, the federal government is a government of enumerated powers, and we don't want those powers to be over broadly construed. So localism is an important theme of these early amendments, and so is populism. The phrase "the people" appears in the First Amendment, the right of people to petition and assemble. The Second Amendment, the right of the people to keep and bear arms. The Fourth Amendment, the Ninth Amendment, the 10th Amendment. The people, the people, the people, the people, the people. Why that phrase? Because remember where the Bill of Rights, in effect, is coming from. It's coming from the ratification conventions in 1787-88, when we, the people of the United States, got together state by state by state and started talking about whether we wanted to ratify the Constitution. And in that conversation, people said, gee, the Philadelphia framers goofed. They forgot a Bill of Rights. State constitutions have bills of rights. We should have a federal Bill of Rights, too. And so the Constitution, the Bill of Rights kind of bubbles up from the people, from this democratic conversation, from epic acts of free speech among the people, and so it's not surprising that the First Amendment affirms the freedom of speech because it's arising out of free speech. It's not surprising that the First and the Second and the Fourth and the Ninth and the 10th speak of the people, the rights of the people, because this is bubbling up from the people, from that preamble process, that we, the people, process of ordainment and establishment. That's what we began the course with, that epic deed, the hinge of human history, when for a year everyone is in a common conversation up and down a continent about how they and their posterity are to be governed. Let me just quickly run down for you what these first 10 amendments say. The First Amendment says that basically there should be no federal suppression of expression, free speech, free press, and no federal interference with religious rights and liberties. So That's the First Amendment. And you see an idea of popular sovereignty. Because the people are sovereign, ordinary people, we should get to decide for ourselves what our political ideas are. Congress shouldn't try to tell us what to say politically, what to think politically. They work for us. We, the people, are sovereign, so they can't tell us that we can't hear certain things. By the way, if you believe that deep idea of popular sovereignty, you should think state governments, they work for us too. They shouldn't be able to shut down political discourse. Incumbents shouldn't be able to tell their challengers, their political opponents, to pipe down or to shut up. But the First Amendment doesn't quite say that in so many words. It says Congress can't abridge free speech. Doesn't say states can. And states actually, although promising to abide by free speech and free press in their state constitutions, actually, we're going to see later in our story, especially in the South, state governments try to shut down free speech. State governments in the antebellum era make it a crime, a capital offense to criticize slavery. The First Amendment's words don't regulate states as such. They don't say no state shall. They say Congress shall make no law. But after the Civil War, there's going to be an explicit amendment saying no state shall violate fundamental rights, including rights of free speech and free press. You might think that principle was implicit in the basic structure of a republican form of government in every state, a system of free and fair elections, but the Bill of Rights doesn't say so in so many words. It's to some extent a states' rights anti-federalist document. The Second Amendment, populism and federalism, local militias, keeping check on a federal army just to make sure that it doesn't tyrannize over us. We want to, the right of the people is paramount here. We don't want basically governments to be who has the guns, who has the power. We want the military power. We want actually our society to be governed by what the people vote for, not what the army prefers. And in case the army ever gets out of line and tries to make itself into a military dictatorship, George Washington won't ever have any part of that, of course. We're pretty sure about that, but what happens after him? Well, state militias are going to be watchdogs. So populism and federalism here. Militias are bodies representing the people. They're all of us. They're cross-sectional, and they're organized locally. A Third Amendment says this army shouldn't be quartered in individual private homes. Again, there's unless Congress explicitly authorizes it, again, an anxiety about a proto-military industrial complex, a culture within a culture of sort of military folks dominating others. Back to the themes of national security that we've talked about so much in this course. We need to create a strong federal military structure, but we need to keep it in check so that we tell them what to do rather than them telling us what to do and think and how to live. So the Second and the Third Amendments are sort of military amendments about keeping the federal military in check, and again, in the name of populism, popular sovereignty. The Fourth Amendment today is about no unreasonable searches and seizures. Today it's enforced by a thing called the exclusionary rule. We'll talk about that in later lectures, in which if evidence is acquired improperly by the government, even if it shows that someone's clearly guilty, it sometimes will be suppressed, excluded from a trial. The framers didn't believe in any of that. Their Fourth Amendment was more about the rights of innocent people. When the government came, the central government, and rifled through your papers or invaded your house improperly, unreasonable, you could sue that official for damages because that was an unreasonable and therefore unconstitutional search and seizure. And who would stand by you if you really had a good case? A local jury would. You'd sue that government official in trespass. They committed a tort against you. They entered your house. They rifled through your papers. A local jury would keep those central officials in check. So Fourth Amendment idea is in part a jury idea. Fifth Amendment has a takings clause. If the federal government starts grabbing your property, you can sue for just compensation. And again, who might decide what that piece of property is worth? A local jury might. And the Fifth Amendment talks about grand juries. And the Sixth Amendment talks about trial juries in criminal cases. And the Seventh Amendment talks about civil juries. Juries are a very big idea, maybe the biggest idea of the original Bill of Rights. and two things about juries. They're populist bodies, they're the people, they're localist bodies. See the ways in which juries are kind of like militias, local, populist. Militias, to some extent, can be seen as sort of jurors with guns in their hands. This is an anti-federalist vision, to some extent, reflecting a little bit of skepticism about the central government. The Eighth Amendment says no cruel and unusual punishments. Well, who's going to be meting out cruel and unusual punishments, possibly? A judge, a sentencing judge, acting without a jury, and we need to be worried about judges acting without juries. Remember, the founders created a powerful judiciary, but it was still third out of three, the least dangerous branch, and they wanted to counterbalance judges with a strong jury check and balance, just as you want to counterbalance the Senate with a House. The Ninth and Tenth Amendments, again, themes of populism and federalism. The phrase the people appears in both amendments, and these amendments are about limited federal powers. So populism and federalism, an anti-federalist vision to some extent. Well, if it's an anti-federalist vision, why do federalists like James Madison go for it? Why is Congress proposing a set of amendments, the first Congress, that begin, at least as ratified, Congress shall make no law? Why would Congress ever limit its own power, you might wonder? Why would the Federalist Madison go for a series of amendments that limit the federal government that he's worked so hard to create? And part of the answer is because the Bill of Rights is part of a national reconciliation project. A bunch of people opposed the Constitution. The Constitution barely passed in a whole bunch of places, and Madison and others want to bring those dissenters on board. And the way you bring them on board is by taking seriously their ideas, seeing if they overlap with yours at all, if you can find some common ground. He wants to bring loyal Americans, American patriots, who voted for the Constitution but were skeptical, or who voted against the Constitution, on board. He wants them to feel part of the project. He wants North Carolina to ratify the Constitution. Remember, it hasn't yet when the first Congress meets. And geostrategically, you want North Carolina. He wants Rhode Island to ratify the Constitution. And this is a face-saving measure. You say to North Carolinians, to Rhode Island people, you say you oppose the Constitution because there's no Bill of Rights? Okay, well, now here's some amendments of the sort that you want. Now will you come in? And you can come in on face-saving terms. Madison also needed to get elected to Congress, and he wasn't going to get elected unless he actually promised his constituents that he would rethink and propose a Bill of Rights, that maybe he had made a mistake in opposing a Bill of Rights in Philadelphia, and that in principle he wasn't opposed to it. He needed to tell his constituents that in order to get elected to Congress, and he wants to get reelected, and if he doesn't keep his campaign promises, they're going to send him packing, and other Congress people understand that too. And if they don't themselves propose some amendments, well, remember, Article 5 says if Congress tries to bottle up amendments that limit Congress's power, there's another way of proposing constitutional amendments. You can have a new convention called. But does Congress want to lose control of the process? If they don't propose some reasonable amendments, maybe the states will demand a new second constitutional convention, which will propose a whole bunch of radical amendments that Congress wouldn't like better, to maintain control of the agenda of the process and propose your own sort of reasonable amendments, your olive branch, your compromise. And by the way, if you're in Congress, you're not probably expecting to be there forever. You're going to leave after a certain point. And when you leave, you want Congress to be limited. Today, people tend to stay in Congress for very long periods of time. At the founding, wasn't as true. And remember the geography, the distance. You're going to be a long way away from your home. There's not jet travel on weekends back and forth. And so people don't stay in Congress forever, the way sometimes today it seems as if they do. So when the early Congress passes amendments limiting Congress, they're not just limiting themselves, but their successors. Some of them are imagining that they're going to go home to the farm. So that's the early amendments. As I said, they're not going to mean very much on the ground for a good long time. The first time the United States Supreme Court holds an act of Congress unconstitutional as a violation of the First Amendment, 1965. And it's not as if Congress hasn't violated the First Amendment before that. John Adams is going to sign his name to the Alien Sedition Acts that make it a crime to criticize the federal government, a crime to criticize the president, notwithstanding what the First Amendment said. Within a decade, you're going to have a repressive congressional law, and courts actually don't enforce the First Amendment vigorously. And in World War I, again, people are put in prison for criticizing the federal government. Eugene Debs, the guy who gets 1 million votes for president, is put in prison for basically saying it's a crummy war and we shouldn't be in it. So these amendments are passed, and it's important as part of a national reconciliation project, but they don't quite fully mean a lot on the ground in court until much later in our constitutional story. And they're going to mean a lot more later on, in part because of the 14th Amendment that takes these rights and applies them against state and local governments as well as Congress. And the Supreme Court is more comfortable beating up on state and local governments, and only once it's done that will it build up all sorts of cases and principles about the Bill of Rights that it can then start to apply against the federal government. That's going to be a big theme of later lectures, so hold that thought. Those are the first 10 amendments. An 11th emerges soon thereafter. It's about limiting federal courts that have been a little too aggressive. Remember, the framers, the founding generation, didn't have as robust a conception of judicial power as we have today. The early Supreme Court was just a shadow of what it is today. It didn't get to decide most of the important constitutional cases of its era. And the one early case that it does decide before John Marshall comes along, a case called Chisholm versus Georgia, people immediately react badly to that. They oppose it. And the 11th Amendment is introduced to overturn a Supreme Court case where the Supreme Court, critics say, has gone too far and accumulated too much power for itself. I don't want to go into all the details. I just want to, they're very technical. If you want, there's lots more information in the book about them, but for now, just see how it fits our larger story of skepticism of federal power and even judicial power. Remember, a lot of the amendments in the Constitution are limiting judges and judicial excesses by providing for juries and rights of criminal defendants, against double jeopardy and compelled self-incrimination, and against secret trials and the like. Trials have to be public and speedy, and all sorts of restrictions on judges in the Bill of Rights. I want to end this discussion of the early amendments with the 12th Amendment, which turns out to be a rather important one. Here's what you need to remember about the founding presidency. It wasn't designed with political parties in mind. Washington stands above party. Every elector votes for him for president the first time around, and then again the second time around. But when he leaves the scene, you actually have contests for the presidency and the emergence of early political parties. So as soon as Washington leaves the scene, remember he's sort of preeminent, you have the next set of founders, the great men of the American Revolution, coming forward. Washington stood head and shoulders, in some cases literally, above everyone else. But when he leaves, when he says, I don't want to be president for life, actually, a republic should be bigger than one man, when he leaves in ways that Ho Chi Minh never does, and Fidel never does, and Mao never does, but he leaves the scene, even though he could have been reelected. The two men who were the next most prominent in the American Revolution, Adams and Jefferson, come to the fore, and they run against each other in 1796. We're about to get to the picture here. Remember, every chapter has a picture, and if you understand the picture, you understand a lot about the chapter. They run against each other in 1796, and Adams wins. Jefferson comes in second, and therefore becomes vice president. Under the founding system, if you come in second for the presidency, you're vice president. And initially, they get along just a little bit, but they begin to become quite antagonistic to each other. Political parties emerge. Adams is the head of one party, Jefferson the other. And then they run against each other again in the rematch in 1800. And that time Jefferson wins. And in the wake of these sharply contested elections, Americans realize they need to change the rules of the Electoral College. Because the Electoral College can permit, basically, people who really hate each other from being president and vice president together. And that's just not a very stable system. That's like an assassination incentive. So they redesigned the rules of the Electoral College so that people can run as a presidential, vice presidential team. Under the new rules of the 12th Amendment, under the new rules of the 12th Amendment, you have people running separately for vice president. So the vice president is no longer the guy who comes in second for the presidency, the guy who may be actually completely opposed to the person who wins. Now you have tag teams, president, vice president, a ticket, so to speak. The 12th Amendment, in other words, is designed to facilitate political parties, mass mobilization, in a word, democracy. It's designed to actually make the world safe for a kind of Jefferson's democratic vision. And so it fits our story of populism. It's about actually encouraging energetic elections and broad political participation. But it's one other thing as well. So Jefferson very much is a small d Democrat. And he's about national security. He's going to acquire Louisiana. So he fits with our story of national security and democracy. But he's also pro-slavery. He talks an anti-slavery game, but he doesn't free his slaves. He pursues pro-slavery policies. And here's what I want you to notice about these two elections. It's North against South both times. That's the dividing line in America. The dividing line in America is not big states against small states. It's North against South. And some people say, oh, the Electoral College prohibits regional candidates. No, these are regional alignments both times. The Southerner, Jefferson, wins the South both times. The Northerner, Adams, wins the North both times. What's the swing state? New York, in effect, is where North meets South. Today, it's Ohio. Those days it was New York, which was a slave state. New York, in the first election, votes for Adams, and the second, thanks to Aaron Burr, votes for Thomas Jefferson, so he wins. It's North against South. But here's what you need to notice. That not only is it America divided North against South, but the South, Jefferson's base, his slaveholding base, gets extra electoral votes because of slavery, a 3/5 clause. Adams understands, and all of his supporters understand, that without those extra electoral votes in 1800, he would have won even the election of 1800. Thomas Jefferson is riding into the executive mansion on the backs of his slaves. The Electoral College is a pro-slavery institution, and it has some flaws, and they modify them with the 12th Amendment, but they don't fix the pro-slavery flaw. They build that, they continue to perpetuate that pro-slavery flaw, that 3/5, into Article 2, in the Electoral College. So, and here we conclude. Because of the 12th Amendment, we're going to have a pro-slavery presidency. It's more democratic, yes, political parties are okay, but we're going to move from Jefferson to Jackson. Very pro-slavery. His party is going to dominate. The dominant political party in America is the Democrat Party, and they're the pro-slavery party. They're going to pursue pro-slavery policies. They're going to put pro-slavery people on the Supreme Court, like Roger Taney in the Dred Scott case, and the war will come as a result of it. Here's the ultimate irony. A 12th Amendment designed to privilege Jefferson's party, they call themselves the Republicans, will, many years down the line, in 1860, that these rules about the Electoral College, which are designed basically to prop up Jefferson's Republican Party, will end up favoring, which is a pro-slavery party. They later call themselves the Democrats. These rules of the 12th Amendment designed to prop up that party will eventually come to benefit a man named Abraham Lincoln, a very different kind of Republican, an anti-slavery Republican. And when he gets elected as the first openly anti-slavery president in American history, sort of despite the rigging of the game in Article 2 against sort of his worldview, against the Northern worldview, when he comes to power, contesting Dred Scott, which is been handed down by Roger Taney, appointed by Andrew Jackson, sort of a Jeffersonian disciple. When Lincoln comes to power, the 12th Amendment is going to be followed eventually by a 13th Amendment. A pro-slavery 12th Amendment is going to be followed by an emphatically anti-slavery 13th Amendment, because in between, the house divided will fall, there will be a civil war, and in its wake, the Union will be rebuilt. A new house will emerge. That's the story for next week. So I hope I see you then. Bye. Welcome back. We've come to another critical turning point in the story of the American Constitution. We've pretty much finished a conversation about the founding era, an era that generates not just the original Constitution and before it the Declaration of Independence, but that also includes the first set of constitutional amendments, the Bill of Rights, Amendments 1 to 10, and the 11th and 12th Amendments that follow shortly thereafter. The 12th Amendment's adopted in the era of Thomas Jefferson. It cements his vision of a more democratic and frankly, a more slavocratic presidential election system. And with that amendment, the founding era, the era of folks who actually had lived through the American Revolution and made and incorporated some of the ideas of the American Revolution, some of its themes, into our foundational document. That era comes to a close. And the next set of amendments aren't going to happen for more than a half century. So now is a good time to pause and to just recap a bit our three themes of democracy, national security, and slavery. Let's just trace just a bit the connections between democracy and national security to begin with. Let's remember that there is no Constitution. It just doesn't exist unless Americans are able to successfully not merely declare their independence from Great Britain, but establish that. And they need to establish that on a field of battle, through a long and bloody war. And they barely win that war. They're very lucky to win that war. George Washington understands that Providence smiled on him again and again and again. It's won only with the help of the French at critical moments, and you can't count on the French in the future. And so Washington understands there's a geostrategic, a national security imperative to create a stronger central government. Because remember, the Articles of Confederation just aren't strong enough to achieve their basic purpose, which is common defense. The Declaration says what we're against. We're against Britain. It says what we're for in terms of principles. We're for unalienable rights of life, liberty, and the pursuit of happiness, no taxation without representation, jury trials, and so on. But how is that going to be, those principles, how are those principles going to be manifest in a new system of government? Well, state constitutions emerged, replacing colonial governments. And at the continental level, we had this Articles of Confederation, which is a loose league, an alliance, a treaty, a confederacy of sorts to coordinate military opposition to King George. And that alliance had as its central purpose, basically, foreign affairs and national security, common defense. And it didn't work well enough because it was premised on the idea that individual states would pay into continental coffers to support the army and the war. Individual states would provide the soldiers, and the problem is the individual states really didn't pony up. They didn't pay when they were supposed to. They didn't always provide the manpower they had promised to. And what do you do if Virginia doesn't pay up? You can't put Virginia in jail. So the Constitution emerges as a national security alternative to the Articles of Confederation and a foreign affairs alternative to the Articles of Confederation. In foreign affairs, the Articles of Confederation promised that America's, that this Continental Assembly would make treaties with foreign nations, but the problem is individual states sometimes violated those treaties and then gave the foreign nations an excuse to not keep their end of the bargain. So Britain, at the end of the Revolutionary War, promised to abandon a whole bunch of forts, and it refused to honor it, using as its excuse, well, different states haven't followed the Treaty of Peace. So since individual states were violating the Treaty of Peace, Britain didn't have to keep up its end, which was to evacuate the forts. Now, as an alternative to that Articles of Confederation regime, we have a constitution that emerges. And the Constitution is going to give this new central government power to not just make treaties, but to make those enforceable law that states are going to have to follow. It's going to have power to impose taxes on individuals. And if an individual doesn't pay, you can put him or her in jail. And with that tax money, it has the power to create its own army and pay for it, and to regulate Western territory, again, something that the Articles of Confederation sort of hadn't provided for. So now we're going to have a much more powerful central government with the power to tax people and raise armies and conduct foreign affairs and negotiate treaties that will really be binding law and regulate the West and regulate interstate commerce and international commerce. And it's a lot more dangerous, because it really can pass laws now that bind individuals. So we have to have some safeguards. It has to be more representative. Because individuals are going to be taxed, they have to be represented. Because it's actually a real legislature that can pass real laws, it should be broken into two, just like state legislatures, and most of the states were. It's got to be bicameral. We're going to need a separate executive branch to check and balance it so it doesn't get out of control the way some state legislatures have gotten out of control. And that separate executive is also going to have be of value in national security, because he's going to be able to be a commander-in-chief and negotiator-in-chief and diplomat-in-chief, and have some weightiness, some gravitas on the international stage. And that's going to be especially true when George Washington becomes president, as everyone expects him to be. You need a separate judiciary, both to enforce these treaties and continental laws against recalcitrant states, and also to check and balance Congress. So precisely because you're creating a more powerful legislature, you need to break it into two, to create a separate executive, to create a separate judiciary, both of which are also going to be useful for geostrategic purposes, to negotiate good treaties and ensure their compliance by states. So the national security imperative now explains a lot of the existing Constitution. Now, who's the big loser in this game with a lot more power in the federal government? The states are the big losers. The state governments, they probably are not going to be as excited about this new Constitution. And so in order to get the Constitution launched, the framers at Philadelphia do an end run around state governments to say, we're going to actually propose our plan to the people themselves rather than to ordinary state governments. We'll get them to sign on. And by the way, we're going to do away with unanimity, because if unanimity is required, Rhode Island will veto the whole project. So as an end around state governments, the Constitution appeals to the people themselves. Driven by this national security imperative, the Philadelphia insiders actually have to play an outsider's game, appealing to the people themselves, going over the heads of state governments. State governments had legitimacy. They had traced back to the colonial governments that had been up and running for, in Virginia's case, 150 years before the American Revolution. But state governments actually might not go for this system that drains so much power for them. So the framers appeal to the people themselves. And if people themselves are going to be asked to ratify it, you're going to have to put in this document a lot of democratic sweeteners, regular elections and no property qualifications for office holders, and all sorts of egalitarian ideas that are going to get the people to vote for the thing. You're going to have to let dissenters speak up, because otherwise there's not going to be a democratic buy-in. So starting from a simple premise of national security, I think we've traced many of the features of the Constitution: separation of powers, bicameralism, strong executives and judiciaries, the very idea of popular ratification, which in turn is going to require all sorts of other democratic sweeteners, and of course leads to that ratification process a Bill of Rights. Because the first thing that people say when they're asked about the Constitution is, what about the rights? Precisely because we're creating a much more powerful central government, we want a Bill of Rights limiting it, just as bills of rights limit state governments, because this new government is a lot more powerful than the Articles of Confederation. Maybe you didn't need a Bill of Rights under the Articles of Confederation, but you do need one against this new government. And when that Bill of Rights is passed, it begins with a promise that Congress won't abridge free speech and free press. Within a decade, Congress does abridge free speech and free press by passing a law in the middle of a quasi-war with France, a naval war, in which John Adams signs his name to the Alien and Sedition Acts, and the Sedition Act makes it a crime to criticize the federal government, makes it a crime to criticize John Adams and to criticize congressional incumbents. It's actually not a crime, interestingly enough, to criticize the vice president, Thomas Jefferson, who's the leader of the other party. It's a crime for challengers to criticize incumbents, but not for incumbents to criticize challengers. And Jefferson and his party thinks that all this stinks. And he mobilizes his folks in the election of 1800 and beats John Adams in the rematch. And when he comes into power, his party constitutionalizes their interest in a 12th Amendment that, as we saw, is pro-democratic in certain ways. It makes for a more democratic, popularly accountable, plebiscitarian, party-based, partisan presidency. So in that way, it actually is encouraging American democracy, which is being channeled through the party system, but it's also more pro-slavery because it entrenches the 3/5 clause compromise that's built into the Electoral College. So we started from a simple premise of national security, and we've deduced a lot of the Constitution from that simple premise. And we bring the founding era to a close with the 12th Amendment, and we see in play the themes of democracy and national security and the theme of slavery, actually, also, especially with the 12th Amendment. Now, that system, the founder system, will eventually fail. We call that failure the Civil War, and part of the reason it fails is, I would say probably the biggest reason, it didn't eradicate slavery. It didn't put slavery on a path of ultimate extinction. It, for example, gave Congress, this Constitution, the power to eliminate slavery in the territories, but it didn't require Congress to eliminate slavery in the territories. And Congress actually chose to eliminate slavery from some territories, but not others. And we were lucky, just lucky, that eventually those free territories predominated. Imagine a world in which most of the early immigration flows into the southwest rather than the northwest. Well, in that kind of world, if the South wins the early foot race for Western settlers, maybe it actually is able to expand slavery throughout the territories. That didn't happen because Northern Indians got defeated first, and so lots of people flowed into Ohio. It didn't happen because lots of European immigrants wanted to come to the Northwest where there was free labor rather than the Southwest where they would have to compete against slave labor, and some of them were simply racist. They didn't want to live alongside lots of black people. It didn't happen because there was less early slave importation than might have been anticipated because there was a slave revolt in Haiti led by Toussaint Louverture. And once that Haitian slave revolt had occurred, some southern jurisdictions were scared of importing too many slaves from the Caribbean because those slaves might have actually been participants in slave revolts or might have seen black people killing white people, and those are kind of dangerous viruses that you'd be importing into your own state if you imported those slaves. So there were fewer slaves that got imported into the South and the Southwest than had been anticipated. More early immigration poured into the Northwest than might have been predicted. And as a result, kind of luckily, the North won the foot race for Western land. The Constitution could have done better. It could have said no slavery in the territories or no slavery in any of the territories after 1808, and it didn't do that. And we got lucky in a way that the North predominated over the South. Now, the structure of the Constitution, remember, through the 3/5 clause, tilts the presidency in favor of the South, and that becomes entrenched after the 12th Amendment, Thomas Jefferson's ascension. And Jefferson is going to be succeeded by Andrew Jackson, eventually, who carries the banner of the party that Jefferson and Madison, both slaveholding Virginians, they found a party that they call themselves the Republicans, but they eventually are renamed the Democrats, and that becomes Andrew Jackson's party. And Jackson is democratic and national security oriented. He's a general who can beat the British and pro-slavery, and he puts on the court pro-slavery jurists like Roger Taney, who succeeds John Marshall, who in the Dred Scott case says, actually, Congress can't prohibit slavery in the territories. Now, that's preposterous. Congress had tried to prohibit slavery in certain territories from 1789 on, the Northwest Ordinance. In the Constitution, it didn't require that Congress prohibit slavery in the territories, but it surely permitted Congress to prohibit slavery in any territory it chose. But by 1857, the Supreme Court is saying otherwise. And when the Supreme Court says otherwise, and when slavery starts to spread even into the Northwest, when Jackson's party has become the party of Franklin Pierce and James Buchanan, and even places north of a certain line are allowed to have slavery in Kansas, in Bleeding, Kansas. When that happens, when the Democrat Party starts to aggressively push a pro-slavery agenda, a man named Lincoln, who had left politics pretty much, comes back in, gets sucked in the 1850s, and eventually will lead an anti-slavery party, a very different kind of Republican party, to victory in 1861. His election is in some ways ironic. He wins in the Electoral College. He gets less than 40% of the popular vote nationwide. But he basically sweeps the North, except for New Jersey and maybe one or two other places, but pretty much fills an inside straight. It wins basically in all the northern states and is elected president through the Electoral College, even though that Electoral College had been designed at Philadelphia and redesigned in the 12th Amendment in some ways to accommodate and even favor slavery through the Three-Fifths Clause. And what is his platform? He is the first openly anti-slavery president in American history. Until then, all your presidents have basically been either Southerners or Northern men of Southern sympathies. That's the phrase. People like James Buchanan from Pennsylvania, Franklin Pierce from New Hampshire, who are Democrats, Jackson's party, and even though they're from the north of the Mason-Dixon line, they basically dance the slave-ocrats tune. They basically are appealing to the base of their party, and the base of their party, which is the dominant political party in antebellum America, the base of that party is a Southern base. So all your presidents before Lincoln are basically Southerners or Northern men of Southern sympathies, and Lincoln is openly anti-slavery, the first openly anti-slavery president in American history. And what's his anti-slavery agenda? Is it he's going to get rid of slavery in the Southern states now? Not at all. He's not an immediate abolitionist. Indeed, he says, I'm not sure that the federal government has power to get rid of slavery where it exists in the states. That's a states' rights issue. His agenda is much more modest than that. Read my lips, no new slavery is basically his motto. In other words, let's try to exclude slavery from the territories. And let's get more, and the territories, if we exclude slavery, which Dred Scott says, you see, you can't do. Dred Scott has proclaimed Lincoln's party's platform basically unconstitutional. Dred Scott has said preposterously in 1857 that slavery must be allowed into the territories. Lincoln's party, the Republican Party, says no slavery in the territories, and we will thereby put slavery, this is Lincoln's phrase, on a path of ultimate extinction. Eventually, these free territories will join the Union on equal footing as free states, and eventually now the free states will outnumber the slave states, and eventually slavery, instead of expanding, will begin to contract. And I think the hope is eventually states on the border will gradually eliminate slavery, as many northern states had already done, and maybe the federal government could give some sweeteners to the remaining states, saying if you get rid of slavery, we'll compensate you for the financial dislocation. So that's Lincoln's plan. It's a 100-year plan. He announces in the 1850s, he says, if you adopt my plan, I think we can get rid of slavery in 100 years or more. So it's not an immediate emancipation, immediate abolition in this plan at all. And Lincoln's being realistic because in the places where slavery has been abolished in some of the northern states, places like Pennsylvania, places like New York, New Jersey, the abolition of slavery had been a gradual affair. And even in Connecticut, where they didn't have very many slaves, it took generations to basically get rid of the small amount of slaveholding that exists. And even in New Jersey, it took generations. The basic idea of emancipation state by state was, let's end, in the northern states, let's end slavery as a system without freeing individual slaves. And here's how we can do it. We can say, after July 4th of next year, the legislature will pass a law. After July 4th of next year, everyone who is born to a slave mother will be an indentured servant for 25 years, the first 25 years, and free thereafter. Everyone who's now a slave will die a slave. And everyone who's born after July 4th will, in effect, be indentured, enslaved for the first 25 years, but free after that. And then, basically, with the passage of time, the slaves die, the indentured servants reach maturity. They eventually are free. Their children are free. Eventually, slavery ends, but existing slave masters basically get 95 cents on the dollar or something like that. They basically get the benefit of their investment for a very long time. The future is given to freedom, but the present is conceded to slavery. That's the Lincolnian compromise. Slavery is wrong, but we can't get rid of it immediately because so much of our economy and society are based on it. So let's put it on a path of ultimate extinction. And the way we do that is first by eliminating slavery, by saying no new slavery in the territories. That's Lincoln's vision. It's very gradual. It's not anything like what eventually happens. What eventually happens is we're going to get rid of slavery everywhere, immediately, without compensation, within 5 years of Lincoln's election. And in the next lecture, I'll tell you how that happened. So stay tuned. Welcome back. It would be nice to think that the eventual elimination of slavery through the 13th Amendment, the promise of equal civil rights for African Americans in the 14th Amendment, the promise of equal voting rights on account of race in the 15th Amendment. It would be nice to think that all of these things, even though they weren't done by the founders, were really anticipated by the founders, that the founders put America on a path whereby things like the 13th, 14th, and 15th Amendments would be the inevitable culmination of a Declaration of Independence that promised that and proclaimed that all men were created equal. It would be a nice story, but it's not true. The framers created, alas, a pro-slavery system, a system that actually got worse and worse and worse as time went on and actually collapsed, broke, fell because of the weight of slavery. The presidency, both in Article II and then in the 12th Amendment, was basically designed to advantage the slaveholding South because the 3/5 clause gave Southern slaveholding states extra clout in the Electoral College. The West was open to slavery constitutionally. Congress could prohibit slavery, but wasn't obliged to do so. And as a result of these facts, the presidency leaned toward the South. Slave states actually became more virulent, many of them in their defense of slavery, more aggressive in their commitment to slavery. They elected increasingly extreme pro-slavery presidents, from Jefferson to Jackson to Pierce and Buchanan. They shut down free speech in the South. It was a crime to criticize slavery in many parts of the South, a capital offense in many parts. North Carolina, for example. Preachers in the pulpit were imprisoned, prosecuted and imprisoned for preaching that slavery was a sin. When Northern congressmen tried to speak out against slavery, Southerners actually tried to indict them for their anti-slavery speech and demand that they stand trial down South. When Charles Sumner gives a speech against slavery, his head is smashed in by Charles Sumner is a Massachusetts anti-slavery senator, and when he gives a speech against slavery, his head is smashed in. He's almost killed by a pro-slavery Southern congressman named Preston Brooks, and the South actually enthusiastically supports Brooks and basically sends him letters saying, hit him again, next time. You didn't finish the job the first time. So the South wants to expand slavery not just into the Southwest, but into the Northwest, into Kansas and Nebraska, wants to acquire many Southern slavery expansionists, Cuba and Mexico, maybe even Brazil, to create a vast slavocratic empire. And there's nothing in the Constitution that prohibits that if they manage to get the votes. And one of the only reasons they don't manage to get the votes is actually kind of luck. Luckily, Americans tend to flow faster into the Northwest than into the Southwest. And so basically, anti-slavery forces win the foot race for Western land in general and are able to thwart some of the most extreme Southern pro-slavery policies. But let's be clear. Abe Lincoln wins in 1860 kind of not because of the Electoral College, in the spirit of the original Electoral College rules, but despite that. The Electoral College was rigged in favor of the pro-slavery South, and Lincoln wins nonetheless. He, as I said before, the first anti-slavery president in American history. And by anti-slavery, he's not extreme. He just is the first president to say, as president, slavery is wrong and we should eventually get rid of it. Now, John Quincy Adams is opposed to slavery. He doesn't love it. But as president, he's got a guy from South Carolina as his vice president, John C. Calhoun. He only starts talking about slavery after he leaves the presidency, when he no longer needs to get Southern votes in order to get himself into the White House. George Washington actually frees his slaves upon his death after he leaves the presidency, but doesn't, as president, ever say, my fellow Americans, we should put slavery on a path of ultimate extinction. I think he does signal that in a way on his deathbed, very kind of quietly. But Lincoln is the first openly anti-slavery president. And in fact, before Lincoln, there's no openly anti-slavery cabinet officer. And as we've seen, the judges, many of them are emphatically pro-slavery, put on the bench by pro-slavery presidents. So the system isn't getting gradually better on slavery thanks to the great wisdom of the framers. It would be nice if that were the story. That's not how it happened. The system is getting worse decade by decade. More slavery. More pro-slavery. Slavery is a cancer that's growing and growing, and you see it in the presidency, and thanks to the Electoral College, and you see it on the court in the Dred Scott case, and you see it in the states when they try to shut down political discourse, and you see it in the West with the Kansas-Nebraska Act and other things that are trying to basically expand slavery into the Northwest. So slavery is this cancer, and Lincoln manages to win despite the built-in headwinds against his anti-slavery vision. And if the South, the pro-slavery South, had been smart, you would never have had anything, even after Lincoln's election, like the 13th, 14th, and 15th Amendments. Lincoln doesn't get a popular majority. He gets less than 40% of the popular vote, a slim majority in the Electoral College. but not a popular mandate of any sort. His party doesn't have a control of the House or the Senate, in fact. So all the South has to do is just wait him out. They've been winning the game almost every time until Lincoln, and all they have to do is basically just say no to everything that Lincoln proposes. Kind of call that like the Mitch McConnell strategy in Obama's first term. All they have to do to Lincoln is just say no, and Lincoln basically is a failed one-term president. He can't really, he's not going to be able to accomplish very much. Here's what he can do. He can appoint anti-slavery governors of the Western Territories who will no longer participate in the rigging of elections in places like Kansas in favor of pro-slavery forces. So he can do a little bit in the West. He can try to ensure that abolitionist literature circulates in the South, because the South has basically banned anti-slavery pamphlets from circulating. So Lincoln, because he controls the post office, maybe can do that. Because he controls appointments of territorial governors, can do a little bit there. He can try to build a bit of a Republican Party in the South, but boy, it's going to be an uphill battle. Abe Lincoln gets 0 popular votes, not electoral votes, popular votes south of Virginia in 1860, because the South has become such a closed, intolerant society. Basically, in effect, it's a crime to be a member of the Republican Party and to support Lincoln's vision when you're down south. And Lincoln can try to do a little bit, but his prospects are pretty limited if the South simply basically shuts him down by staying at the table and blocking everything. But instead, the hotheads in South Carolina and elsewhere take up arms against a duly elected government. At Fort Sumter, fire upon the Union flag, even though Lincoln had been elected fair and square, and even though secession was unconstitutional under the founding for reasons that we've talked about at great length. But the hotheads in South Carolina first unilaterally declare their secession before Lincoln has even taken office in December of 1860, and then in early 1861, shortly after Lincoln's inaugural address. Lincoln hasn't done anything particularly provocative, really, but they launch an unprovoked bombardment of Fort Sumter. And as a result of that, their hot-headedness, they bring about something that was utterly unimaginable had they simply played the democratic game. The universal, immediate, uncompensated emancipation of slaves within the next 5 years. And it's just stunning that something like that could happen. Rarely in history have cannons backfired so explosively. So why, in retrospect, were they so dumb? But if they had played the game long term, maybe slavery might have ended, even on Lincoln's agenda, in 100 years. But they would have gotten 95 cents on the dollar. They would have gotten all the value of their slaves. They would have been able to transition to new economic ways of life. So why were they so dumb? And my answer basically is because they were arrogant and drunk with power and evil. Slavery is tyrannical. Tyrants actually live a life of arrogance, and they actually are contemptuous of others. They don't want to hear other points of view. So they were overconfident about their military prospects and their constitutional vision, and they shut down people who tried to say otherwise, who tried to argue, Southerners, that the slavery was actually not very good even for the South. They tried to shut down discourse, and as a result, they basically shot themselves in the foot. They, in the same way that lots of tyrants over the course of world history have basically made fundamental miscalculations because they shut down information flows because they just didn't want to hear things that were at all critical of their opinions. And when you shut down information flow, you actually weaken your society in some very important ways. This is the long-term strength, it seems to me, of open, free, democratic cultures. Here's the story of how we eventually get the radical 13th Amendment. Lincoln gets elected despite the 12th Amendment. The South secedes by force of arms. And they put up a pretty good military show. And so eventually, Lincoln is forced as a military measure to issue the Emancipation, and as a diplomatic measure, the Emancipation Proclamation. His initial proposal is simply, come back to the Union. I won't tinker with slavery in the States. You know, I'm going to stand on my platform of excluding slavery from the Western territories, but that's not really going to prejudice your economic interests in any immediate way. So, and I promise that I'm not going to mess with slavery in the States. And if you like, I'll support a constitutional amendment to that effect. That's what Lincoln says in his inaugural address, a very different kind of 13th Amendment. But the South spurns that deal. Lincoln is initially just trying to bring them back in, but after the war proceeds, in the fall of 1862, he issues his preliminary Emancipation Proclamation, which, as a war measure, is going to provide for the freeing of certain slaves in the rebel territories. Now, why does he do that? Again, it's as a war measure. Two ideas. One, he's worried as diplomat-in-chief. Remember, the foreign policy and geostrategic considerations the president has to keep in mind, because the Constitution is very much about national security and geostrategy. He's worried that England, that Britain, might recognize the Confederacy. They have certain economic interests. Southern cotton feeds and fuels British textile mills. And Britain doesn't care about American Union as such. Britain had fought against the American Revolution, had fought America in the War of 1812, has its own territories in the New World, Canada and elsewhere, and might not like nothing better, maybe from a certain imperial British point of view, that have the former American colonies sort of divided against themselves so Britain can play its classic divide and conquer game. So if it's just a war about American Union, maybe Britain sides with the South. But if it's a war to end slavery, if Lincoln can redefine the meaning of the war originally fought for union, but now Lincoln with the Emancipation redefines it as a war for freedom, for the end of slavery, British public opinion will not allow Britain to side with the South. Textile workers, even in Britain, at the risk of their own jobs, will actually support Lincoln's vision and will oppose any British effort to recognize the Confederacy. So there's a foreign policy dimension to the Emancipation Proclamation. Keep England out of America, just as the Revolution had been designed to sort of kick England out, keep them out. And there's a more immediate war aim. If you take all the Southern manpower represented by the slaves, that they're propping up the plantations, they're freeing up labor. If they working the fields, then they're freeing up the, masters and overseers, white labor, to fight on the battlefields. So they're helping the South for its basic economic base. If all those slaves instead stop helping the South and actually join the Northern cause, and maybe some of them join the Union Army, well, that's a lot of manpower to take from one pan of the scale and put it to the other, and Lincoln thinks that might very well be the margin of victory, and it turns out he's right. 180,000 blacks in blue end up fighting. Former slaves and their kinfolk in the Union in places like Kentucky flock to the Union lines. You have all that manpower that had been supporting the Confederacy in effect, and now it's supporting the Union cause, and that's the margin of victory in some important respects. This will help a strategy that will culminate with smashing victories in not just places like Gettysburg and Vicksburg, but in Atlanta. And Lincoln wins re-election. And when he wins re-election, some of you have seen the movie Lincoln, he uses his renewed mandate to push through a 13th Amendment that's going to say slavery must end everywhere. And this is radical, not just in the former Confederacy, but even in Union states like Kentucky and Maryland and Delaware, Missouri. West Virginia has also sort of joined the Union during this time period. So slavery has to end everywhere, not just for rebel masters, but even for loyal Union masters in places like Kentucky. Slavery has to end everywhere immediately, now, not in 20 years or 50 years or 100 years. Slavery ends now, immediately, and there's no compensation. And a later provision of the 14th Amendment will actually say it's illegal for a government, state or federal, to compensate the slave masters. So immediate, universal, uncompensated emancipation of a sort that no state had ever adopted before the Civil War. This is a radical moment in American history, made possible only because, actually, the South so overplayed its hand, generating a huge backlash and resulting in the carnage and cataclysm of the Civil War. Without that, you would have never had the 13th Amendment in the form. It was not some gradual fulfillment of the deep spirit of the founders who put America on a proper future course, even though they didn't eliminate slavery themselves. That'd be a nice story to tell, but that's not how it happened. The founders messed up on slavery. They created a pro-slavery system that got worse and worse and worse. This cancer, and the cancer became so bad it almost killed the patient, and radical measures were needed as a result, and Lincoln was able to do that only because of the Civil War, only because the South was dumb enough to secede, frankly. So that's the story of the 13th Amendment, and it ends with, it says, no slavery shall exist anywhere, and that means actually if a private person tries to enslave another individual, governments are obliged to intervene. This is a radical provision. It has no government action requirement. It limits even private parties. It requires government to act to free people from slavery. And there are all sorts of forms of slavery. There's agricultural slavery. There's sexual slavery, compelled prostitution. There's child abuse. Some of the slaves actually were children. There are many different forms of tyranny that we could think about as forms of slavery, and the 13th Amendment prohibits them all in Section 1 and gives Congress sweeping power to enforce that vision in Section 2. Remember, the Bill of Rights, in the afterglow of the American Revolution, began Congress, which was about anxiety about an imperial center. So the American Revolution is localist, and the Bill of Rights that emerges says Congress shall make no law of a certain sort. Enter the 10th Amendment, very states' rights-ish, very anti-federalist. But now the 13th Amendment is going to end with the words, Congress shall have power to enforce this. And by the way, we're going to see that sentence in the 14th Amendment and the 15th Amendment too, because the Civil War is a war in which the good guys are not the state governments, the colonial governments, the seceders, but the central government. And so this new Constitution that's going to emerge after the Civil War, this new constitutional understanding, is going to be far more nationalist. Congress shall make no law. These are going to be amendments that, in fact, limit state institutions and practices like slavery. Well, you might think, okay, once you've gotten rid of slavery, job done, let's move on. And I think Lincoln's party initially might think that, and then they immediately realize that they've miscalculated. Do the math. What happens once slavery ceases to exist? Now all these slaves become free blacks in the South. So how's that going to work? You still have the Electoral College. You still have the apportionment rules of the House of Representatives. Now all these free blacks who aren't being allowed to vote in the South will nevertheless count in the Electoral College, count in the House of Representatives census, but not at 3/5, because that's how they counted when they were slaves. They still counted, they still added to the Southern strength, but with a discount, 3/5. Now that they're freed, thanks to the 13th Amendment itself, they're going to count at 5/5. They're going to count for even more. So the concern is the South is going to come back into the House of Representatives, come back into the Electoral College with even more clout than it had before. Not letting its blacks vote, but getting even more votes, because now the 3/5 has become 5/5. And so the Republicans immediately realized that they're going to need at least another constitutional amendment, and that amendment is the 14th. And it's huge. It's probably the most important feature of our Constitution. We're going to talk about it again and again and again over the course of the lectures to follow. So let me just very briefly identify some of the things that the 14th Amendment does. Its first sentence says that everyone born in America is born an American citizen. We're all born citizens here. We're all born equal citizens here. Black and white. I would add male or female, Jew or Gentile, gay or straight, because it doesn't use the word race. This overturns the Dred Scott case, which said not just that slavery had to be allowed in the territories, but also that basically free blacks could not be citizens. And the 14th Amendment says, oh, yes, they can. Constitutionally, we're all created equal. We're all born equal. It's a constitutionalization of a radical reading, a broad reading, Lincoln's reading of Thomas Jefferson's Declaration of Independence, all men are created equal. That's the first sentence. It says everyone's an equal citizen in America, black as well as white. So you're not just free. It's not just that we're ending slavery. You are a citizen. You're an equal citizen. The next sentence of the 14th Amendment, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So now we move from a Bill of Rights that says Congress shall make no law to an amendment that says no state shall make a law. Remember, who misbehaved before in the Civil War? It's the state governments. And so now we're going to have, in effect, a second Bill of Rights, a Bill of Rights against the state governments. We needed a Bill of Rights against the central government after the American Revolution, and we got one. But now we need a second Bill of Rights against state governments. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And note that some of the same words of the First Amendment are now appearing in the Fourth. No, shall, make, law, abridge. That's in the First Amendment. That's also in the 14th Amendment. But now it's no state. Now, what are these privileges or immunities that no state shall abridge? Fundamental things in America, like the Bill of Rights, like speech and press and petition and assembly and free exercise and a right to be free from unreasonable searches and seizures and due process and jury trials and right of counsel, etc., etc. These fundamental rights, freedoms, privileges, and immunities which had been before being guaranteed thanks to the Bill of Rights against the feds, are now going to be guaranteed against states, because states had misbehaved so badly, had shut down free speech and free press and even preachers in the pulpit, free exercise, and done all these things. And now we need a second Bill of Rights to make sure that they don't do that again. So you might say, well, gee, if the 14th Amendment was about, and this is a thing called incorporation of the Bill of Rights against the states. That's how lawyers and judges talk about it. And you might think, well, gee, if it's about incorporating the Bill of Rights against the states, why doesn't it say Bill of Rights? And the answer is because it's about more than just the Bill of Rights. It's about other unenumerated rights and freedoms, the privilege of the writ of habeas corpus, proof beyond reasonable doubt, all sorts of other fundamental things, the right to testify in your own behalf as a criminal defendant, and all sorts of other fundamental rights and freedoms. So it's about even more than the Bill of Rights. And the phrasing that they used was apt, privileges and immunities of citizens, because, remember, the Constitution doesn't call these early amendments a Bill of Rights. We do today, but that's in large part because the framers of the 14th Amendment called them the Bill of Rights. The founders, not so much. The Supreme Court never referred to the early amendments as a Bill of Rights before the Civil War. They did refer to these amendments as privileges and immunities of citizens. And so the 14th Amendment says states can't mess with these things. And you might say, well, if states can't mess with these things, why did they say due process in the next sentence or the next clause? Because isn't due process a privilege or immunity that already is covered? So why a separate mention of due process? And the answer is the due process clause protects persons above and beyond citizens. The only folks protected by that first privileges or immunities idea are citizens. But the framers of the 14th Amendment thought persons deserved protection as well. And they also said persons deserve equal protection and due process. Now, here's one thing the 14th Amendment didn't do. It didn't guarantee a right to vote. You might say, well, why isn't voting a privilege or immunity of citizens? Well, remember in Article 4, way back when I go I'm a Connecticut person, to New York, I get all sorts of civil rights, but not a right to vote or to serve on a jury. So political rights under Article 4 were seen as not covered under privileges or immunities of interstate citizenship, nor are they covered by the 14th Amendment, which is about privileges and immunities of citizenship that I have against my own home government, not just when I go to New York, but against Connecticut. I have certain rights, speech, press, and so on, but the 14th Amendment doesn't quite give me a right to vote yet. Today, courts say equal protection gives you a right to vote. It's not so clear that originally that's what was intended, because remember, equal protection is about persons as distinct from citizens and aliens especially, and they've never had a right to vote before. And that's why all the framers of the 14th Amendment, actually, to a person, to a man, said this isn't about voting rights. This is about civil rights as opposed to voting rights. And why did they insist on that? Because they didn't have the votes at the time to get a voting rights amendment through. But they will, just shortly thereafter, with the 15th Amendment, get a voting rights amendment through. How are they able, with the 15th Amendment, to get through what they weren't able to do in the 14th Amendment? And the answer is the 14th Amendment did have some rules about voting. And the rules about voting, which are in Section 2, said if you don't let basically black people vote, then you get fewer seats in the House of Representatives and the Electoral College. And then the framers of the 14th Amendment did one. So as a practical matter, that was going to really penalize the South because it had a lot of black people and not so much the North, which had fewer. And then the framers of the 14th Amendment did one other thing. They said, we're not going to let the Southern governments back into the House of Representatives and the Senate until they promise to let black people vote, and in fact until they ratify the 14th Amendment. And you might say, well, why was that okay? And that's because basically these Southern governments were un-Republican. They didn't have free speech, they didn't have free press, they weren't letting black people vote. Black people were a majority in some of the Southern states, a huge plurality in others, and so it just wasn't right. Once these slaves become free, you can't prevent them from voting. If they're slaves, that's one thing. It's like aliens can't vote. But once an alien becomes a citizen, it's very different to prevent them from voting. Once these slaves become free, it's very different to prevent them from voting. Yes, some northern states prevented blacks from voting, but that was a small percentage of the population, say the Republicans, 1-2%. Whereas in the South, it's 60%, 50%, 40%, 35%. It's much different to exclude a huge population base. So how do you get the 15th Amendment? Once you impose black suffrage on the South, then they come back into Congress, and these new Congress people will support an amendment to constitutionalize that everywhere, to have black suffrage in the North too. And that's the 15th Amendment. Now, who's upset by all of this? Among others, women. They're saying, why are you enfranchising black people before some of whom are illiterate, many of whom are illiterate? Why are poor, illiterate black men getting the vote before Radcliffe and Smith educated white women? And there are a couple of arguments. One is that blacks fought on the battlefield, and voting rights are connected to arms bearing. And another is you can count on men to protect the women in their lives. When the men vote, they'll protect their wives and mothers and daughters and sisters, but you can't count on whites to protect blacks. So we're going to come back to that story. And the women are not quite mollified by these stories. So they're going to, once we have an amendment that says in the 15th Amendment, no abridgment of voting rights on account of race, women are going to say, let's add sex to that. And that's going to be a story that we're going to come back to in the next couple of lectures. But I'm going to end this one by, once again, reminding you of the image in the accompanying chapter of America's Constitution, a biography. It's chapter 10. Shall I trust these men? This is Lady Columbia, America. Shall I trust these men, these former Confederates? They want sort of back in. Shall I let them back in? Robert Lee and others. Shall I trust these men? And not this man, a black man who's lost his limb in service of America. He's wearing a Union coat and a Union uniform. Black men win rights initially rights to be free, later rights to be an equal citizen, and eventually rights to be an equal voter, because they fight and bleed for the Union on the battlefield of glory. Remember the story with Denzel Washington and Matthew Broderick in that movie, the Massachusetts 54th. So once again, here we see deep connections of the three great themes of American history. Democracy. Democracy is being extended to those, to black men. National security, in part because of a war that gives them a chance to shine and show their stuff, their virtue. So national security and democracy and the story of slavery. But now we move from a pro-slavery constitution before the war to an emphatically anti-slavery constitution after the war. That's the great Reconstruction. That's the constitution we live in today. Now, Lady Columbia is a female embodiment, and as I said, she's personified here as white. Many women are not very happy that they're being cut out of this deal. There's going to be another great war in America at the beginning of the 20th century, World War I, and women are going to get the vote in that war and because of that war. So the national security story that we see here, that we saw at the founding and that we see in the Civil War, will continue. And that's the story, among others, of the next two lectures. So please stay tuned.